March 25 has been set as a date when the Constitutional Court will hear an application by the State Capture Inquiry to have former President Jacob Zuma declared to be in contempt of court. The Commission had launched the application last week after Zuma failed to appear before it. It wants the former president to be jailed for defying two summons sent to him in January and February. Meanwhile, the Jacob Zuma Foundation has accused Justice Zondo of abusing his position as second in command of the Constitutional Court. Karyn Maughan is a senior legal journalist at News 24. Karyn, a very good evening to you, and thank you so much for taking the time to speak to us. Let's just first start with the accusation made by the Zuma Foundation that under the Commission's Act, those who act in breach of summons risk a fine of 6 months in prison, not a 2-year sentence as being recommended by the Commission to the Constitutional Court. You and I have had a discussion about this. Do they have the same interpretation?
No, I think the important thing to stress here is that it is a highly unusual thing to ask for a 2-year sentence in the case of contempt. But what the inquiry has said, its Secretary Itumeleng Mosala has said under oath, is that because there were multiple acts of contempt involved here, that the former president chose in 5 consecutive days not to honor a subpoena issued against him to appear in February. He did not appear in January. He also walked out of the inquiry on the 19th of November. We know there's a separate NPA case or decision in that regard about criminal prosecution for that. And he also made a number of statements attacking the integrity of the Constitutional Court and also launching scathing attacks against several other judges who had ruled against him, that this 2-year sentence was appropriate. Mosala actually said that if Zuma had been prosecuted in the criminal court, he could have faced, because of all these different actions, a potential sentence of 4.5 years behind bars. But I think what's interesting is that we may see a sort of slight walk back on this prison sentence issue if and when this matter is argued on the 25th of March, and certainly a suggestion from the foundation that, they may not be opposed, Zuma may not be opposed to a suspended sentence if that's the way the court intends to go, under the proviso that he actually does testify.
In fact, the Commission Secretary Itumeleng Mosala himself has said that should the court choose the suspension of sentence route, then the Commission would then have to make special arrangements to accommodate his testimony before the lifespan of the Commission expires. So do you think this ultimately would diffuse tensions, and should this have been the first recommendation, to start with?
I think the important point is that contempt proceedings are usually never really result in someone going to prison. Typically what happens is in the High Court, an order is given against government or whoever, they fail to comply with the order. The threat of arrest or prosecution for contempt is then used, a jail term is then used as leverage to basically get them to comply with the directives of the court. We know the Constitutional Court has, out of its own volition, launched contempt cases in the past. I think there are about 5 of them. But certainly we haven't ever seen someone go to jail. And I don't think for 1 minute the Constitutional Court wants to be in a situation where outside of the ambit of a criminal trial, they're sending the former president to jail for 2 years. I think that they are very likely to say, in the condition that they do opt for a prison sentence in the circumstances of this case, that it should be suspended and throw the ball back very much in the former president's court, that he must then make a decision whether he's prepared to go to jail, as he said before that he is, to defend his belief that his rights have been infringed in a truly intolerable manner, or whether or not he will actually opt to go to the inquiry, provide them with the evidence that they've requested from him in relation to Eskom and PRASA, and avoid that jail time.
Now, it's been suggested that the former president, by his lawyers, that he met with Justice Zondo in his chambers on the 19th of November and offered to respond to questions privately rather than take the witness stand. The Commission has denied this offer was made. But what should we make of these suggestions that the former president has and was willing to appear before the Commission, but it was under different circumstances? Is there credence to these claims?
Well, we do know that, when the former president was unwilling to participate in the inquiry in July 2019, that an offer was made that he would provide a written statement in response to certain areas of interest that were given to him by the inquiry. And of course, we know that he failed to do so. We know that it was a very highly charged situation. We know that the DCJ, Raymond Zondo, seemed to be at pains, to allow Zuma, for example, to express his thoughts about the alleged apartheid foreign intelligence agents' conspiracy against him, which he claimed had found its full zenith, as it were, in the commission itself. But I think there were overtures made of some kind, certainly in regard to the former president actually providing written statements and not necessarily coming before the inquiry. But, Tsepiso, unless the person actually makes good on those promises, which began, I think, in July 2019, there's very little that the commission can actually do. And as far as we know, there is certainly no written recordal of such an offer being made at this point. It's really now in the realms of what was said behind closed doors, and they're two very different versions of what actually happened there.
Given the fact that the former president's legal team has said that we shouldn't put the horse before the cart, the cart before the horse, in that there is still going to be a review of the Deputy Chief Justice decision or whether he should preside over the commission when the former president testifies. How important is this to apply this lens when there is this date that we've mentioned of March 25 that's been set?
Well, the difficulty for the former president is that he's brought that case on a non-urgent basis. And as far as I know, it's pretty much stalled. Nothing really further beyond, the initial filing has occurred. So there's no timeline, no sense of when this is actually going to be heard. And second of all, he didn't bring in an interdict application. He didn't say, look, I fundamentally believe that the DCJ Zondo is biased against me. I cannot possibly in these circumstances appear before him. I'm going to challenge his decision not to recuse himself. And in the interim, I will bring an interdict to stop these subpoenas from being issued against me, or I will challenge those subpoenas in court and have them declared unlawful. He didn't do any of that, and the Constitutional Court in its decision was made aware by the inquiry of this pending recusal application and said, basically gave a directive that the former president must obey the summons and subpoenas and directives issued against him by the inquiry lawfully. And he has chosen not to challenge their legality. So really, his argument about the recusal application somehow, putting a brake on him being expected to appear, I don't think stands much credence. And I think that it will be addressed in this Constitutional Court on a case on the 25th of March.
All right. Thank you so much, Karyn Maughan, senior legal journalist at News 24.